So at this time, I will now call the applicants, who are Shirley Nunn and Jeffrey and Sarah Tamayo, or they can have their representative come, and you have 10 minutes.
Thank you. Mr. Chair, Supervisors, thank you very much for this opportunity. Mike Durkee, representing Ron Nunn and Jeff Tamayo. You've gotten all of our writings. I'm not going to belabor the points. I do want to reserve our right that we've already been automatically approved. I do recognize we're not a tentative map. You incorporated by reference the MAP Act sections that give an automatic affirmation in your certificate, and in doing so, you brought onto yourself the automatic affirmation. But I do want to address the substantive issues this afternoon, and I'll be very quick and work within the time frames given. And again, thank you for that. I have 3 main points that I would like to make. People forget that in California, property is 3-dimensional. That means that we go from the chewy chocolate center of the earth to the marshmallow heavens. Everything in between is what we hold as property. So if you would imagine, at the Planning Commission, I had the opportunity to use an easel. I'm not going to do that today, but I'm going to ask your mind's eye to paint the following picture. I have this gorgeous cake, and it goes from the center of the earth to heaven. The bottom layer, below the surface, is Devil Foods cake, my favorite, gorgeous chocolate cake. The surface of the earth is this great buttercream frosting, and above it is white angel food cake. And that's what Mr. Nunn holds. And he's sitting out there, and his predecessors are sitting out there, and they're enjoying this one big cake. And along comes the county. Now, if the county had taken its finger and drug it across our buttercream frosting, we'd still have one cake. So I absolutely disagree with the appellant when she says that an easement has the same impact legally as does a fee. It simply doesn't. And we'll be happy to have the argument here for you for the future that nobody who has an easement can ever say they divide property. You cut off my hand, I lose a hand. You cut off my arm, I lose an arm. You cut off my head, I lose a life. You can do all 3, but they clearly have different consequences. When you take a fee, you take my big, beautiful cake, and you cleave it from the highest place that the law allows property to go to the lowest place that property allows it to go to, and you cleave it on that side. And then when you want to strip, you cleave it on the other side. And any child in this room would know that that cake now is 3 pieces. The piece you took for yourself in fee, and the 2 pieces left on the plate for me. And then you come back and you cleave it again, and you take the strip going perpendicular. And now we know that on the plate for me is 4 distinct pieces, and you have 2 of those. There's nobody in this room that's arguing that you don't have 2. They're just saying us, nobody who asked for this division. Somebody who sat out there and you came along with your condemnation powers is not free to ask for a recognition of the consequence of the way you decided to do the take. That's it. The second point I want to make is this idea of precedence. And with all due respect, that to me is boogeyman's under the bed. When you know that your legal argument doesn't work, you scare people politically. My God, this could mean something else. I don't know what it is, because I don't want to define it to you, because that might take away its scare value, but it must have one. So we looked at least the property that is involved with us. We looked at the Los Vaqueros EIR, and we looked at the Vasco Road relocation EIR. And as Supervisor Pifos said, they are absolutely agriculture in nature. The EIRs for both say there will be no environmental consequence from these condemnations because this is already agricultural land, and it won't be changed from that. We're in a general plan designation of agriculture. We're in a zoning of agriculture. As you've all pointed out, we're in A4, agricultural preserve, and we have a Williamson Act contract. Now, you don't usually hear a property owner saying we have less rights than staff are willing to give us, but we would argue that we don't even have a right, even though the contract might say so, to put in a residential unit because the Williamson Act wouldn't let us if it would impose on or impair the right to do agriculture. Residential under the state law for the Williamson Act must always be incidental to agriculture. Our American family farm is an American family farm because we live on the land and can take care of it. But if a 45-acre property was too small to sustain agriculture and a residential unit, you and your staff would be allowed to say the Williamson Act contract for that piece of property does not allow. Not because the contract says it can, because the state law says it can't, and state law always trumps. But Mr. Nunn to me just now whispered, when we do new contracts on these 4, he's absolutely happy to have that contract say no residents will be allowed on the, it'll be the one that's there and no more. And we will, into your record today, tell you that we're happy to not have those residents. Because what's Mr. Nunn actually doing with this property? What your general plan says, what your specific plan says, what your zoning says, and what his Williamson Act contract is. He's bringing wine to East County, and he should be applauded for that. So I represent the California land surveyors, and some of you, when we came to meet, said, is this a novel idea? Because we're being told by everybody, the appellant, that you have a novel idea. Is it a novel idea? So I put it out to the blog. California Land Surveyors Association has a blog. I had 17,000 hits on my question, and the question was, when we divide by fee versus easement, do we divide? And the answer came back, absolutely. San Diego County recognizes that. Sonoma County, when they put in Highway 80, recognized it on either side, et cetera. Some of you said, well, that's great, but can you tell us locally if people agree with you? So I said, absolutely, I'll find out. So I asked the city attorney for the city of Dublin, when they put in Dublin Boulevard going east into the East Dublin planning area, I knew they did it in fee. Did you recognize that you had divided property? Absolutely, we gave certificates to the people on both sides. Contra Costa called up the Walnut Creek city attorney, Brian Wentner, who is very involved in the MAP Act and represents the League of California Cities on MAP Act issues. And he was, in fact, involved with 66428A2, the law that, according to appellant, is good enough for you to take your pieces of cake, but not good enough to say the result of your legal action is also legal parcels that have been created. Evidently, that section, according to them, doesn't apply. And Brian said, no, as far as cities concerned, it does apply, and we absolutely recognize that there would be 4 legal parcels there. He sent me an email. I printed it out for you for your record. I then called Napa County Council, because Napa County is probably one of the biggest ag counties we have in Northern California, and they likewise said, when we put in the road and fee, we say it divides property, we issue certificates. And I printed out that email, and I brought it today. I then talked to the Martinez city attorney, Jeff Walter, who's also a city attorney for the city of Sonoma, city of Corte Madera, city of Novato, etc. I said, you know the question, you know the answer. He said, of course, we recognize them. Every single person I talked to said, that is not a novel idea. That's absolutely the way that we do it every day. So then we called Contra Costa Water District. And Contra Costa Water District says it divides land. That every time we do a take, says Contra Costa Water District, we believe that we divide land. Hence, if you look at where we take our takes, everywhere possible, unless gravity requires us to relocate the line, we follow property lines because we know we divide when we condemn and fee. And the reason, to answer one of the questions raised, that they sometimes condemn and fee is so that they can prevent people from going under the property. So when we took in fee, I'm stealing the thunder of somebody that might speak today, we lost our slant drilling rights. When you took your condemnation in fee, if it was one piece of parcel and it was ours, we could do anything on it, right? We would be able to drill anywhere we wanted to. We can't. We cannot slant drill across because your take is three-dimensional and we would be a trespasser if we do. And the nuns do oil and gas as well as agriculture. So we instantly lost that. That is clearly apparent that this was the creation of Ford. I've probably gone past my 10 minutes. I appreciate your time and attention. Happy to answer questions. Oh, one I will offer, and I apologize for that. You have a general plan. You have specific plans. You have zoning. We have been in the process for 2+ years, and we instantly figured out from the Los Vaqueros EIR what properties were involved. If you have a general plan, you have the right to absolutely not allow building as a right, to require, as the city of Lafayette does, that if it worries about an errant parcel that might go forward, they have what they call single lot review. And they've turned by their local police power an additional land use tool that they can use to make sure that when they need it, they have that arsenal. You are not going to be troubled by a ministerial permit that the MAP Act recognizes just gives us a right to be sold, leased, and financed. We do not have a right to use except the way you decide that we have it to use through your general plan.
Okay, thank you. I don't know if you stated your name initially, but if you would do that for the record.
Absolutely. I apologize if I didn't. Mike Durkee.
Okay, thank you.
Thank you.
Supervisor Anderson, followed by Mitchell.
Yes, thank you. And you've actually answered several of my questions I was posing before you came to your conclusion. Beyond the slant drilling, are there other ways that the use of the property is currently being impaired by the fact that it has been physically divided?
We can't plant certain crops. Because obviously, we can't go into the Vasco Road right of way. But on the pipeline, we can have certain access. We can't put in vines, so Mr. Nunn has to be careful where he puts his rootstock. Can't put in trees, can't put anything that would be intrusive that could go downward, that could mess up pipes. So we can put in certain crops that have a shallow base, but we can't have full use. So he has to tailor his trellis and his crops to recognize those easements.
Okay, terrific. And then you answered my question about there would be no concern of your clients with regard to entering into Williamson contracts on each of the separate 4 parcels.
That is absolutely correct. And if you look at the Williamson Act contract, we were accused of not following the Williamson Act contract. But in fact, you divided our land. We didn't. And the Williamson Act contract is very clear that it doesn't go away. You have a right unilaterally to file a notice of non-renewal if you want to from your own action. But that new contracts are let for each of those. And in fact, it says if we never do contracts, this original contract still runs with this land. So if we never did contracts, we wouldn't have to give up the right to do additional housing units, but we're happy to do that. This is an agricultural pursuit. And I agree with your legal counsel that you do not have a precedential value. The only precedence you have is to follow the general plan and be the land use people that you are. Certificates of compliance never give a right to develop. And in fact, one point I meant to make, and I apologize for not doing so, back in the early 90s, I was on the Assembly's MAP Act committee. Such a thing existed. And we were stakeholders, and we all had input on what the law should be. And one of the concerns was certificates of compliance. And I sat with the Sonoma, Napa, Ventura County, San Luis Obispo County, places that are very anti-development that didn't want to have certificates. And our compromise was to have now, which is required by law, to be printed on all certificates. You don't have a right to develop. This is a recognition of your lot is legal. Your right to develop will be a product of the general plan, specific plan, zoning, and so forth.
Thank you.
And then just one final question of Mr. Durkee. So based upon your last comments, you don't feel that there's a concern that we are setting a precedent, for particularly with residential. Admittedly, agricultural is not an issue. If we do have a taking that takes place in an area and we end up with a very small remnant non-conforming lot, you don't think the county would then be somehow required to approve a house or other structure built on that non-conforming lot based upon our action?
That's absolutely correct. I would tell you that whatever you have for a minimum lot size, counties always wrestle with this. Cities never do. Cities know you might have a lot that's too small. You're not putting a house on it. Maybe your neighbor will want to buy it. It might have some market value. Maybe you can have the biggest lot in the neighborhood, but you're not putting a house on it because our general plan doesn't let you. Counties are the ones that seem to wrestle with the idea that you can have a lot that's too small, but we still have to give you a house. You don't at all.
Thank you.
Thank you. Supervisor Mitchell.
Thank you, and thank you for your presentation. It was very helpful in clarifying some issues I have. The one question I do have, and you mentioned it when you came up, was that Mr. Nunn said that he would be happy to agree that he's not going to build, or Mr. Tamayo won't be building any more homes. So why do we need 4 certificates?
That's a great question, and I apologize, Chair. I'll try to make it very brief. Land-based financing in California requires that you go to the legal edge of the property. If we had 4 legal edges, we could do what's known as rolling loans. So the reasons that places like Napa and Sonoma are very good about giving certificates and lot line adjustments is they're nothing but farmers. They're nothing but ag people. Right now, Mr. Nunn has 1 loan on the outside of that big piece of property. If he had 4, he can put 1 piece of property in grape and have a special grape loan from a grape bank on it, while he spins the other one into something else. It gives him more collateral because all farming is land-based financing. They are going to put a deed of trust against that land. So if you have 4, you can clean one, and you have to pay off the entirety of 600 acres worth of loan. You can pay off 45 acres worth of loan and re-roll a new loan onto it. It's the very reason that the #1 industry in California asking for certificates and lot line adjustments is agriculture, not development.
Okay, thank you. That's the last comment that I have. Thank you
Thank you very much.
for your presentation.